Welcome back to the online lecture Introduction to German and International Company Law. In the first podcast, we finished our short overview over the partnerships. Now we turn to the corporations. For the energy sector and big businesses in general, the corporations or capital companies are much more relevant. In this podcast, I will give you an overview over the general characteristics of corporations under German law and then introduce you to the two most important types. The Gesellschaft mit beschränkter Haftung, GmbH, also called Limited Liability Company, and secondly, the Aktiengesellschaft AG or Stock Corporation, Stock Company. First, you will get an impression of how corporations can be organized in general. In international perspective, there are two general types of corporations: the private limited companies and the public limited companies. A private limited company is a closed corporation and cannot be listed on a public stock exchange. Its primary means of funding is therefore not the trading of its shares on the capital markets. If it needs fresh money, either the shareholders need to increase their share or it needs to go to a bank for a loan. A private limited company has typically few shareholders and is in structure more similar to the partnership. Because there is no public participation in the inner workings of the company, the shareholders are mostly much more free in designing the agreement and the structure of their company. The public has not to be protected from unusual agreements. For the typical purpose of running a small to medium-sized business operation, partnership or private limited companies are mostly interchangeable. However, in general, there's a strong tendency by businesses to favor private limited companies. Examples are the German GmbH, the BV in the Netherlands, Benslotten Vennootschap, the SARL, Société à Responsabilité Limitée in France and Luxembourg, or the OOO in Russia. Also the limited company Limited in the United Kingdom. A public limited company, on the other hand, can be listed on a stock exchange to collect funds on the capital markets. Such a move does only make sense if the company has reached a certain size and wants to improve its access to capital. Public limited companies typically have numerous shareholders, most of which normally will remain anonymous. However, some major shareholders may try to influence the company's business strategy and be very vocal in advancing their interests. However, it is not mandatory for a public limited company to be listed on a stock exchange. It is also possible for it to just have one or few shareholders and to be more similar in structure to a private limited company or a partnership. But most of the time, this does not make sense, as the legal framework is mostly much stricter than in other types of companies. Most legal systems treat the public limited company as the prototype for a company operating on the capital markets and therefore allow only a very limited degree of flexibility to protect the members of the public who want to participate as shareholders. Examples for the public limited companies besides the German AG are the French Société Anonyme SA, the Russian AO, the public limited company PLC in the UK, and the corporation Corp or incorporation in the United States of America. The limited liability company or private limited company, in German called Gesellschaft mit beschränkter Haftung, GmbH, is governed by the Limited Liability Company Act of 1892. In German it's called Gesetz betreffend die Gesellschaften mit beschränkter Haftung, or short GmbH-G. The limited liability company is a German invention without any precedent in history. The objective was to fill a gap between the existing types of associations, the stock company on the one hand and the partnerships on the other hand. In Germany, the GmbH is by far the most common legal type for companies. There are around 1 million GmbHs today, and the number is growing. This extraordinary popularity is due to some key characteristics. First, the Limited Liability Company Act requires only comparatively small contributions of capital by its founders. The risk associated with setting up a company is therefore very limited. However, in reality, this is offset by the practice of banks and other creditors to demand personal guarantees by shareholders before making substantial investments. So, if an undercapitalized GmbH goes bankrupt, the shareholders will mostly suffer the same fate, although not because of company law, but because of separate collateral agreements. Second, the other major advantage, especially in comparison to the stock company or AG, is the large degree of flexibility in designing the Memorandum of Association. We will later see that the stock company has much stricter regulations concerning its internal organization. The internal organization of the GmbH, on the other hand, may to a large extent be structured as to suit the particular needs of its shareholders. The GmbH can be adopted to serve the purposes of small or medium-sized corporations and family-held companies, as well as those of big business. However, the courts, being more flexible than the legislator in adapting the law to practical experience, have developed several doctrines to limit both the freedom to form the articles and the exercise of rights conferred on individual shareholders by the Memorandum of Association. The limited liability company is frequently used in combination with a commercial partnership in the form of a so-called GmbH & Co. KG. This kind of company is a limited partnership in which a limited liability company rather than a natural person occupies the position of the general partner. Let's talk about the formation of the GmbH and the Memorandum of Association. The incorporation of a limited liability company is governed by statutory law. It requires a contract, Memorandum of Association, or in German Gesellschaftsvertrag or Satzung, between the founders in notarized form. The notarized form is dispensable only if there are fewer than 4 founders and only 1 managing director, and if the founders use the standardized Memorandum of Association provided for by the law. The capital must be fully subscribed upon formation of the company, once at least 1/4 of each share has been paid and further capital requirements have been met. The managing directors can apply for registration in the commercial register. Upon registration, the limited liability company acquires legal personality. The limited liability company, the GmbH, may be formed by 1 or more founders. The founders are the subsequent shareholders, may be natural persons or legal persons. Even a general partnership, a limited partnership, or partnerships under the German Civil Code can be founders. In contrast to many other countries, there is no limitation on the number of shareholders in Germany. The Memorandum of Association, the Gesellschaftsvertrag, must state at least the company's firm name and registered office, the objectives of the enterprise, the amount of the share capital, and the amount of each shareholder's contribution, as well as any other obligation put upon the shareholders. The company's internal organization, as well as the shareholders' rights and duties, may be structured by the shareholders in the memorandum. In practice, the memorandum usually sets out supplementary and detailed rules referring to shareholders' accessory rights and obligations, the obligation to make an additional contribution, or rules regarding to the representation and management of the company, or shareholders' meetings and resolutions. An amendment to the Memorandum of Association requires a special resolution of the shareholders' meeting by a qualified majority of at least 3/4 of the share capital represented at the meeting. Amendments to the Memorandum of Association must be notarized and registered in the commercial register. The company's firm name may either indicate the company's purpose or the name of a shareholder or any imaginative term or combination of these variants. It must have a distinctive character and must not be misleading or confusing. In any case, the name must include the addition with limited liability, in German mit beschränkter Haftung, or the abbreviation GmbH, as a warning to creditors of the limit upon shareholders' liability. Furthermore, the registered office must be determined in the Memorandum of Association. A change of the office within Germany is affected by an amendment to the Memorandum of Association and its entry in the commercial register. The share capital, in German Stammkapital, amounts to at least 25,000 euro. There is no limit on the maximum amount. The important function of the share capital is that of a liability basis in order to protect creditors. The level of share capital can be altered only by the strict procedure of an amendment to the Memorandum of Association. One very important aspect of the law of the GmbH is the contribution of the share capital, as it is the basis for the company's credit. There are strict rules to ensure that the limited liability company obtains the required share capital. Each founder subscribes to one or more shares, on which a capital contribution has to be submitted. The sum of the shares' capital contributions must correspond to the amount of the initial share capital. Shareholders' contributions may be paid in cash, so-called Bareinlage, or be made in kind, so-called Sacheinlage. A shareholder may not set off a contribution. The company may not waive a shareholder's obligation to contribute. Transferable assets may constitute payments in kind, for example, land, buildings, know-how, businesses, copyrights or trademarks. If subscriptions are paid in kind, stricter provisions apply. Otherwise, it would be very simple to circumvent the capital provisions. The Memorandum of Association must clearly specify the items to be contributed by the shareholder and state their value. The founders have to produce a report in which they substantiate whether the value of contributions is equivalent to the amount stated in the memorandum. If a business is transferred as payment, the balance sheet of its last 2 financial years must be added to the report. If the value of the contributions in kind is less than the value stated in the memorandum, the respective shareholder is liable to pay the difference. The provisions to guarantee the payment of the share capital contributions are complemented by provisions to ensure the maintenance of the share capital and by provisions to protect creditors. It's called the principle of the effective maintenance of the share capital. The company may neither pay a share capital contribution nor distribute the company's assets to the shareholders if such a payment or distribution endangers the amount of share capital fixed in the Memorandum of Association. Shareholders receiving payments contrary to that in bad faith are required to refund the amount. In the event that a refund cannot be obtained, all shareholders are liable in proportion to their shares. Pursuant to Section 33 GmbH, the limited liability company may acquire its own shares only if the entire contribution has been paid in and if the payment to purchase the shares does not endanger the amount of the share capital or the capital reserve. The share capital can be increased only by an amendment to the Memorandum of Association and allotment of new shares to each existing shareholder and/or new shareholders. The statutory law on capital increase generally refers to the rules of the incorporation. To preserve the ownership structure of companies, new shares must first be offered to existing shareholders in proportion to the nominal value of their share capital. That's called a preemptive right, or in German Bezugsrecht. Preemption rights may be wholly or partially excluded by a special resolution of the shareholders' meeting. A share capital increase is valid and takes legal effect as soon as it has been registered. The law also provides for the so-called Unternehmergesellschaft, entrepreneurial company with limited liability. If the founders want to establish a corporation with a smaller amount of the minimum capital. It suffices if the UG holds capital ranging between €1 and €24,999. If the capital is increased to €25,000 or more, the UG is converted by law into a GmbH. In order to protect creditors, contributions in kinds are forbidden and the UG has to transfer 25% of the net income of a year to the capital reserve. This reserve may only be used to cover losses or to carry out a capital increase from the company's funds, which is the usual way to convert a UG into a GmbH. The UG is the little sister of the GmbH. Apart from these peculiarities, all other provisions of the GmbH apply to the UG. Next, we will turn to the corporate bodies, which are very vividly described in German legal terminology as organs of the company. The statutory organs of the company are the managing director and the meeting of shareholders. A supervisory board is not required by law for a regular GmbH. It is only mandatory in companies with more than 500 employees, or it can be established voluntarily by the Memorandum of Association. It is also possible to establish a committee with merely advisory function, which has no supervisory power over the managing board or which has supervisory power. It's called Beirat or Verwaltungsrat. The extent of both the mandatory and voluntary organ powers depend on the Memorandum of Association as long as there are no mandatory statutory requirements. First, we will take a look at the managing directors, which manage the company's day-to-day business and represent it when dealing with third parties. The company must have one or more managing directors. In contrast to the partnership, managing directors do not need to be shareholders of the company. Only natural persons with full legal capacity can be appointed. Persons convicted of certain offenses, for example in relation to bankruptcy, may not be appointed. In practice, most managing directors of limited liability companies are shareholders rather than third parties. The managing directors jointly represent the company in and out of court. The law provides that the directors manage the business jointly, but the Memorandum of Association may grant managing directors the right to act alone. Shareholders can impose internal restrictions on the ability to act on behalf of the company. However, such limitations are not effective against third parties. Managing directors are responsible to the company for the diligent performance of their duties and are liable for any damages caused, unless they acted upon instruction of the shareholders' meeting. Managing directors are obligated to ensure that proper accounting records are kept, and they have to submit the financial statements to the shareholder meeting. They are required to call a shareholders' meeting at least once a year. Furthermore, they must provide information on the company's affairs to shareholders. In the case of bankruptcy, managing directors are required to file a petition for the commencement of bankruptcy proceedings. Managing directors are nominated by the Memorandum of Association or appointed by a resolution passed in the shareholders' meeting. The Memorandum of Association may set out special requirements with regard to the appointment of managing directors, for example, additional standards regarding the qualification of managing directors, age limits, etc. If the company has a supervisory board pursuant to the Code Determination Acts, it is the board that is responsible for the appointment of the management. Now we will take a look at the shareholders' meeting. It must be called by the management at least once a year. By statutory law, the shareholders' meeting is the most powerful organ. It is formed by all shareholders together. Each euro of a share entitles a shareholder to one vote. Therefore, one share, one vote, unless otherwise provided in the Memorandum of Association, for example, multiple voting rights. Shareholders may not vote in the resolution on their own discharge from liability claim or on legal transactions relating to them. A shareholder may be represented at a meeting by use of a proxy in text form. The shareholders' resolutions do not need to be notarized unless the resolution alters the Memorandum of Association. It is possible to assent to certain decisions by written agreements outside the shareholders' meeting. There are no specific statutory provisions relating to errors and defects in shareholders' resolutions. The prevailing opinion is that provisions of the Stock Corporations Act should apply. Thus, every opposing shareholder may contest the resolution in court in order to obtain a court order. The resolution is then void or invalid. As pointed out previously, the shareholders' meeting appoints, supervises and dismisses the managing directors. It decides on amendments to the Memorandum of Association, on the approval of financial statements, and on the distribution of profits. The resolution needs to be passed by a majority of votes cast unless the Memorandum of Association provides otherwise. Decisions on the basic legal structure, on the purpose of the company, on an amendment to the Memorandum of Association, on a capital increase or reduction, on an amalgamation or a merger, on a conversion into a stock company, on the dissolution of the company have to be passed by a qualified majority of 3/4 of the votes. Unless otherwise provided in the memorandum, managing directors are subject to instructions from the shareholders' meeting. Thus, a majority of shareholders can determine all business of the company. Therefore, the limited liability company is considered the most appropriate corporate legal form of a subsidiary. The dismissal of a managing director requires a resolution of the shareholders' meeting. In practice, the Memorandum of Association often provides that managing directors may only be dismissed for good and sufficient cause. Next, we will take a look at the Aktiengesellschaft AG, or stock company in English. The stock company is a tool to collect funds and spread the risk of large enterprises. It has access to the capital markets and is typically managed by professional outsiders. The typical shareholder is not involved in the day-to-day business of the stock company and has no influence on specific business decisions. First, we will take a quick historical overview to international and national development of the stock company as a legal form. This will make the topic more vivid and provide you with some perspective. The stock company can be found in nearly all modern legal systems. Its origin can be traced back to the large-scale overseas trade by the Arab and Italian merchants of the Middle Ages in the Mediterranean and the Indian Ocean. But its current characteristics formed during the age of European colonialism. The governance of European nations chartered corporations to run colonial enterprises on other continents. The prime example are the Dutch and British East India companies. These corporations were more akin to sovereign nations because they owned the monopolies on lucrative trade ventures like the spice trade from India and Indonesia, and had armies and fleets in their own right and waged war without the official military support of their home nations. The Dutch East India Company was the first company issuing shares and trading them publicly on the Amsterdam Stock Exchange. Through this mechanism, the company could acquire huge sums of capital and fund its costly ventures. The advantage for the shareholders was the limited liability for the losses of the company. But in an age when piracy and warfare on the high seas was still widespread, the investors ran huge risk of losing their contributions when the assets of the company like ships and trading posts were lost. Later, the stock company as a legal form became one of the major drivers of industrialization. In the 19th century, the big railroad companies in Germany and the United States were incorporated as stock companies because they require huge sums of capital to set up infrastructure before actually turning a profit. The speculative investment in railroad company stocks was one of the major drivers of the boom and bust economic style of the 19th century, especially in the United States. In Imperial Germany, from 1870 onwards, the law of the stock company was originally regulated in the Commercial Code, HGB. During the economic crisis of the 1920s, there were extensive discussions to create a separate code for the stock company due to its importance and the special mechanics compared to other types of companies. In 1937, the first Stock Company Act was introduced. However, it was heavily influenced by the ideology of Nazi Party. The management board was disproportionately powerful to reflect the top-down totalitarianism of the German state at the time. After the Second World War, this was one of the reasons why the stock company was not very significant. The other reason was that the war and the economic hardship that came with it had wiped out much of the private savings. So there weren't many private funds to invest. Instead, companies had to rely mostly on bank loans. In 1965, the Stock Company Act, Aktiengesetz, Act G, was reformed in a major way and forms the basis for the modern German stock company. The General Meeting or Shareholders Meeting became more powerful, and the totalitarian heritage of the 1937 law was eliminated. But the shareholders are still not nearly as powerful as in the GmbH. The Stock Corporation Act has been amended several times since 1965, mainly to implement the European Union Company Law Harmonization directives. However, the principal objectives of the amendments between 1994 and 2020 were deregulation and modernization. Since the 1990s, the stock company has had a resurgence in Germany because the capital markets are now more developed and there is enough wealth in the broader population to allow for substantial private investment. But the German capital markets still pale in comparison to the United Kingdom or the United States. Today there are roughly 19,000 stock companies in Germany, but of which only around 3,000 are publicly traded on the capital markets. Let's take a look at the characteristics of the stock company, its formation, its corporate governance, and then we will compare the AG to the GmbH to highlight similarities and differences. The stock company is a corporation with a fixed capital stock divided into transferable shares. Shareholders are not personally liable for the company's obligations. The stock company, a legal person pursuant to Section 1 of the Stock Corporation Act, has an incorporated organization. Regardless of the actual purpose of the enterprise, the stock company is always deemed to be a commercial company. Same is true for the GmbH. The formation of the AG is quite similar to that of the GmbH. The stock company becomes a legal entity upon registration in the commercial register. To qualify for registration, several requirements have to be fulfilled. The Memorandum of Association is drawn up by one or more founders in notarized form. Section 23 of the Stock Corporation Act sets out minimum content requirements for the document. Further stipulations are possible, but may only differ from the Stock Corporation Act if the law explicitly allows for deviations. Because such expectations are rare, German stock company law is rather strict in comparison with other legal systems. Here we see the advantage of the GmbH in matters of flexibility that I mentioned earlier. Thus, the setting up of an EG makes sense when you want to collect funds on the open market. One of the reasons for this is the standardization of shareholder rights. Because of that, the shares can be traded more easily on the capital market. No potential shareholder needs to know every last bit of the Memorandum of Association before making his investment decision. The founders have to subscribe for all shares and pay the amount of capital that is determined in the Memorandum of Association. The minimum amount of capital for the stock company is €50,000. Section 63a, The Stock Corporation Act requires the company to call up at least 25% of the issue price of a share and the entire premium where shares are issued for an amount higher than the nominal value, with a so-called agio. A shareholder may not set off contribution and the company may not waive the obligation to pay the shares or to repay the contributions. Contributions in kind must be verified by independent auditors to determine whether they are equal to the amount stated in the memorandum. The founders elect the first auditors and the Supervisory Board, the so-called Aufsichtsrat, which in turn appoints the first Board of Directors, so-called Vorstand. The founders, the Supervisory Board, the Board of Directors and the first auditors are subject to special civil and criminal liability rules in all respects relating to the correct incorporation of the company. The successful formation ends with the registration in the commercial register. Now we will explore the corporate governance of the stock company. There are different structures for governing a stock company in different legal systems. For one, there are countries which follow a monistic approach or a one-tier system. This model is prevalent in the Anglo-American tradition. On the other hand, there is the dualistic approach or two-tier system. You can find this model mostly in the legal traditions of continental Europe like Germany and Poland. This categorization is only a very broad one, and the specific approach differs from country to country. In the Anglo-American one-tier system, the corporation is governed by a board of directors, which in turn elects the executive officers. The executive officers, like the CEO, the Chief Executive Officer, or the CFO, the Chief Financial Officers, run the day-to-day operations of the company. The non-executive directors on the board take over the supervisory role. In the two-tier system, the operational management is the task of the managing board. In Germany, it's the Vorstand. The managing board is elected and monitored by a separate supervisory board. In Germany, it's the Aufsichtsrat. The members of the supervisory board cannot be involved in the operational management of the company. Both models have advantages and disadvantages, but tend to function pretty well in the respective legal system. Now we will turn to the specific structure of the German AG. The Stock Company Act requires that each stock company has 3 and only 3 required organs. The General Meeting or Shareholders Meeting, called Hauptversammlung, and as stated before, the Supervisory Board, Aufsichtsrat, and the Managing Board, called Vorstand. The Managing Board manages and represents the AG. The Supervisory Board monitors and counsels the Managing Board, and the General Meeting has only restricted powers, is weaker than in the GmbH. It has no direct influence on the management. The company's management and representative organ is the Managing Board. Its members are elected by the Supervisory Board. The Managing Board may consist of 1 or more persons. A company with a share capital of more than 3 million euro must have at least 2 managing directors, unless the Memorandum of Association provides otherwise. Only natural persons with full legal capacity may be board members. Persons convicted of certain offenses, for example in relation to bankruptcy, may not be appointed. The appointment is for a maximum period of 5 years and is renewable. The same applies to the employment contract between the appointed persons and the company. It is one of the subject matters of such a contract to fix the remuneration and other terms of employment of board members. The law provides for special stipulations concerning the financial compensation of directors, such as salaries, profit sharing, expenses allowance, retirement and pension plans. The Supervisory Board may dismiss a member of the Managing Board for cause, for example, following a vote of no confidence of shareholders at the General Meeting. The management of the company is the sole responsibility of the board. The board is not subject to any specific instructions from the general meeting or the supervisory board. It represents the company in and out of court. The powers of the board to represent the company with regard to third parties are unlimited and may not be limited through special provisions of the memorandum. The managing board develops the business strategy for the company and implements it in coordination with the supervisory board. The internal powers of the board may be limited by the declared purpose of the company, the Memorandum of Association, the Supervisory Board, and by certain resolutions of the General Meeting. The most important limitation is that the Memorandum or the Supervisory Board may require certain decisions or transactions to be undertaken only with the consent of the Supervisory Board. In addition, members of the Board or of Directors have fiduciary duties toward the company that may limit the Board's internal competence. The Management Board is also responsible for the corporate compliance of the company. This means that they have to make sure that all duties that the company needs to fulfill by law or because of its internal policy are followed. To achieve this purpose, they have to implement a system of appropriate controls to make sure that all levels of the company follow those duties. With this, they make sure that the company does not get into trouble and does not take over unnecessary risk. When performing those duties, board members must apply the care of a diligent and prudent manager. Members of the Board of Directors who fail to fulfill their duties are jointly and severally liable for any damages caused to the company. To also guarantee an appropriate level of business initiative despite the liability risks, German law took over the so-called business judgment rule. It reads, "No violation of duty if at any time of taking the entrepreneurial decision they had good reason to assume that they were acting on the basis of adequate information for the benefit of the company." This standard was first taken over into German corporate law by the Federal Court of Justice, BGH, in the Arak-Garmenbeck decision. It originates in the corporate law jurisprudence of US-American courts and considers the specific uncertainty of entrepreneurial decisions. It tries to eliminate the hindsight bias if a business decision fails. Because of the knowledge of eventual failure, a judge may be tempted to see a breach of duty in making the decision. On the basis of the business judgment rule, however, any evaluation must consider just the information available at the time of the decision itself. Next, we will turn to the Supervisory Board. It's an independent organ and normally elected as a whole by the General Meeting for a maximum period of 4 years. If provided in the Memorandum of Association, some members of the Supervisory Board may be appointed by certain shareholders. The board consists of at least 3 members. The memorandum may set a higher number. The maximum number is determined in relation to the amount of share capital. A company with a share capital of more than 10 million euro may have a supervisory board of 21 members. There exist special requirements for companies falling within the scope of the Co-Determination Acts. In these cases, a specific number of board members have to be elected by the employees of the company and not by the shareholders' meetings. By less than 500 employees, all members are elected by the shareholders' meetings. 500 till 2000 employees, 1/3 of the members of the supervisory boards are elected by the employees. And when the business has more than 2000 employees, half of the members of the supervisory board are elected by the employees. Only natural persons with full legal capacity may become board members. The memorandum may prescribe additional personal requirements such as age, nationality, or special professional qualifications. The accumulation of memberships in supervisory boards of different companies is limited to 10. Certain overlaps in capacities are prohibited. Thus, for example, a person serving on the board of directors of a subsidiary company may not be a member of the supervisory board of the parent company. The Supervisory Board appoints and supervises the Board of Directors. Supervision extends to all activities of the Board of Directors and pertains to both the legality and the commercial soundness of these activities. If a member of the Management Board breaches its duty, the Supervisory Board also enforces the damages claim. In order to ensure proper supervision, the Board of Directors must report regularly on its activities, at least 4 times a year. If necessary, the Board of Directors must inform the Chairman of the Supervisory Board of any important developments in the company or its subsidiaries. The Supervisory Board may call the General Meeting if the welfare of the company requires it. In addition, the Board must give its consent before certain decisions can be taken. Finally, there's the General Meeting or Shareholders Meeting as the third mandatory organ of the AG. It is the assembly of all shareholders. It has to be called at least once a year. In addition, it must be convened in cases provided for either by the Memorandum of Association or by law, for example, if a minority demands so or when it becomes necessary for the welfare of the company. The voting rights are distributed according to the principle of one share, one vote. Shares with increased voting power, so-called golden shares, are not possible under German law. However, there are shares without a vote which only provide dividends for the shareholders, so-called Vorzugsaktien. In general, a decision needs to unite the majority of the shares represented at the meeting, except the law requires a qualified majority, especially by amendments to the Memorandum of Association. The General Meeting's competence is not comprehensive, but limited to questions assigned to it by the law or by the Memorandum of Association, such as the election of the members of the Supervisory Board, the appropriation of earnings, the discharge of the members of the Board of Directors and of the Supervisory Board, the appointment of annual auditors, the amendment to the Memorandum of Association, changes in the capital basis, certain decisions relating to the law of affiliated companies, conversions and fusions. For example, amalgamations and mergers as regulated by the law regulating the conversion of companies, the so-called Umwandlungsgesetz. If we now look at the whole picture, we see some similarities between GmbH and AG, but also some major differences. Both GmbH and Stock Corporation require the notarization of their Memorandum of Association and the registration on the commercial register. Therefore, they are more public than partnerships. Furthermore, the shareholders are not liable for the company's debts, and the insolvency of the company only results in the loss of the provided capital for the individual's shareholder. In contrast to the GmbH, however, the law of the AG is very strict concerning its organization and the other content of the Memorandum of Association. And while the Shareholders Meeting of the GmbH has a huge influence on the managing directors, the shareholders of the AG have only a very limited power. In the AG, the Management Board operates with much more discretion and independent from specific instruction from the Shareholders Meeting or the Supervisory Board. The publicly traded stock company has also a very different shareholder structure because its shares can be traded on the capital market, which results in a high fluctuation in membership. With this, we conclude the part on German corporation law, and in the next podcast we will take a look at the influence of the European Union on company law.